I work as a senior policy advisor in European digital rights. We're an NGO that represents 35 other NGOs across Europe and beyond. So the goal of this panel today is to explore the relevance of the notion of personal data as a trigger for the application of data protection law. As in the future, any piece of information could legally become personal data. And why do we have the General Data Protection Regulation? Why are we fighting for a strong e-privacy regulation? Why do we have over 100 data protection laws across the world? Personal data protection and privacy are fundamental rights, and these won't and should not change in the future, regardless of the future of a data-driven society, because fundamental rights protection is here to stay. Article 8 of the Charter of Fundamental Rights of the EU says that everyone has the right to the protection of personal data concerning him or her. Article 7 of the Charter says that everyone has the right to respect for his or her private family life, home, and communications. And the fact that potentially any piece of information in the future could have become personal data is not necessarily a problem per se. It is clear that in some cases, identifying natural persons is not needed to have an adverse effect on people. An example could be targeted advertising, where it is not necessary to know who exactly the person is, but it's enough to know that this person is the same person who earlier visited websites on a number of topics to have an adverse effect on the person's personal data rights and privacy rights. So, as a lawyer, it is fascinating to explore the minor differences in the definitions on personal data in the Directive 95, in the GDPR, also in the Convention 108, to also explore the opinions of the Article 29 Working Party, and most importantly, also to hear from experts and academics on the concept of personal data. So today I have the honor to chair this session with Dr. Nadia Purtova. She will be our moderator today. She's Associate Professor at Tilburg Institute for Law, Technology and Society, and she's the Principal Investigator of the InfoLeg project. We also have the pleasure to have Mr. Peter Hustinx, who was the first European Data Protection Supervisor and also former chair of the Dutch Data Protection Authority. He's now retired, but as you can see, he's at the core of the discussions on data protection still, and we're so happy to have him. But also Professor Dr. Maurits Kaptein, a professor of data science and health at the University of Tilburg. He's author of several popular books on the use of personal data in machine learning and data science applications. We also have Dr. Frederik Borgesius, a researcher Marie Curie Fellow at the LSTS group of the Free University of Brussels. And currently he's mainly focusing on research on automatic profiling, the risks of unfair and illegal discrimination in that context. And finally, but not least, obviously, we have Dr. David Stevens. He's currently a data protection officer for Europe at Nielsen, and before he was in the similar role in Telenet. Are you excited about this panel, as I am? I hope you enjoy the discussions on personal data, whether personal data is still relevant trigger for the protection in a data-driven society. We'll be taking questions on the floor, so please be patient.
So thank you, Maryant, for excellent introduction, but perhaps I'll take a couple of minutes just to give a feedback of the panel. And so the panel is a part of the ERC project exploring the future of the notion of personal data and how sustainable it is in the short term or foreseeable future as the trigger of legal protection against data-driven harms. So as the project, the panel will also aim to look at the future of the concept of personal data as the trigger of legal protection. So we will look at the meaning of the concept as it is construed now, but we will also consider the viability of arresting the entire system of data protection law. Oh, excuse me. So I'm not sure from which point you stopped hearing me, but I'll recap. So the ERC project I'm working on at Tilburg Institute for Law, Technology and Society in the Netherlands explores the future of the notion of personal data as the cornerstone of legal protection against data-driven harms. And so we are not here to argue that the data protection obligations should be relaxed or restricted. We are here purely to look into the sustainability of the notion of personal data as the cornerstone of the data protection law. So, because we will focus on the future of data protection and future of the concept of personal data, this panel hopefully will be provocative rather than descriptive in nature. And let me just go through the few departing points that I think will be a good foundational skeleton for this discussion. Well, so we already know that the notion of personal data is contested. Multiple scholars argue that this distinction between personal versus non-personal data does not work anymore. Personal data is dynamic and context-dependent. Identifiability or re-identification of anonymized data sets is failing, as some argue, and some as well, me amongst those, argue that all data may potentially impact people, and so all data relates to people, and so all data is personal data. So this is perhaps one of the provocations. The question we would like to explore here today together is whether or not the notion of personal data is sustainable as a cornerstone of legal protection for the future, and if we have to look for an alternative organizing principle to build the legal protection, and what this principle could potentially be. So to kick off the discussion and just to have some reference points on the screen, here is the definition of personal data as it is given in the GDPR, which is not much different from the definition in the Data Protection Directive. And personal data is any information relating to an identified or identifiable natural person. And in particular, we would like to structure the discussion along the explanation that is given to this concept by Article 29 Working Party in its opinion 136, and the recent case law of the Court of Justice of European Union, which break the concept into 4 elements: any information, regardless of content, format, or medium, information relating to a natural person by reason of content, purpose, or effect, and that individual has to be identified or identifiable given all means reasonably likely to be used by the controller or any other person. And that individual has to be a living natural person. So this is the background of the panel and a backbone for the discussion. And I would like to kick off the discussion by asking the speakers one general question to which I would like to ask you to give just a brief answer, state your position, and you would have a chance to elaborate your position further in your individual answers. So, do you think we have reached the tipping point at which we should reconsider the role or the meaning of personal data as a trigger for data protection law? So, have we reached this point, or will we reach this point in the foreseeable future? So, shall we start from my right?
My answer is clearly no. We have not reached that point. I'm firmly on the position that the definition as it is okay. There is no reason to reconsider, but we have just finished a thorough review, and that is the conclusion in the EU framework. It's the Council of Europe framework, the OECD, etc. The emphasis should be on making the protection work better in practice. Just a little footnote, it's not just a trigger for data protection as such. This concept appears in virtually all provisions in the framework, so it is essential to defining the relationship between all the actors. Just an example, I have access to the data relating to me. If I stand in face of a bank, all data which have a relevant impact on me are within the scope of the right of access. So we are discussing the essence of the essence. It is designed to protect. And that's what it should be doing.
I think it's an important discussion to have and a fun thought experiment. Like, are other possibilities of regulating data possible than using personal data or personally identifying information, something similar as a trigger? I cannot think of another way. I want to add, though, that I could imagine that in 20 or 30 years, the law looks a bit different. Perhaps that we have like the core principles in an overarching data protection law with more sector-specific rules on top for various cases. And already we have rules that regulate some types of data use. For instance, non-discrimination law is silent on what type of databases you build, but is triggered when you do certain things with those data. And such rules on top of data protection law can also be useful. Still, I guess I'm conservative because I think we should continue with personal data like trigger for the rules.
I guess we can use
Hey, sorry about that. Yes, so this was a wire. It's hard for me to meaningfully comment as not being a law scholar, but somebody who works with personally identifiable data and works on statistical methods for personalizing treatments, primarily in the medical domain. But I do think, and this kind of relates to the first comments, that perhaps as is, the definition is clear enough and workable enough and refined. However, its practice is hard for those that are actually currently working with it. And it's hard for those like me who encounter these types of data on a daily basis to make a reasonable judgment as to where this starts and to not slip into, which I think is your worry as well, a point where any kind of source of data could potentially be personal data, and especially where that boundary is and kind of how that should play out in practice, I think is one of the main discussion points.
Okay, thank you. First of all, I think I need to say that I'm not really speaking on behalf of Nielsen or my former employer, but just reflecting myself here. We're more appealing my academic background in the past than my current employer's view. So for me, this is a little bit the Chatham rules that should are applying, I hope, even though we are recording this stuff. Just us, not you. And we all consented to it, I hope. Let me start with a little story, if that's allowed. When I started at Telenet, which is a local cable company providing television and telecom services here in 2013, privacy was the, I hear background noise. Privacy was the topic that had to be done by the last one joining the legal team. The youngest one, the one who couldn't really resist or refuse to do it, had to do privacy. And in 2013, I came from academia after 14 years, and I said, guys, it's not an issue. I'm not the youngest one, but I'll gladly do privacy. So I started to do privacy in the context. It was almost a hobby. It was not my real job. I had a real job, which was supporting the content acquisition division. And that's how I started doing privacy for Telenet, which has quite a significant amount of personal data in 2013. That's 5 years ago. In the meantime, I think we managed to dramatically change the way and the maturity in how we treat personal data. We had when I left, which is a couple of months ago, we had a program in place with all kinds of teams involved. So not only legal, and definitely not only the youngest one legal, technology was involved, security was involved, risk management was involved, marketing was involved on a regular basis. We had a proper GDPR program. But that's only 5 years ago. And the reason why I'm telling you this story is because my view, I think, is similar to what Peter has been saying, and I think most of us have been saying. In industry, my experience is we only just started really implementing this stuff. In the past, it was legal doing it, and if only legal is doing stuff, and I'm even now in a legal department, so I can tell. If only legal is doing stuff, then nothing really happens, I would say. It's a little bit of a... I'm over-exaggerating to get everybody awake. But now it's an interdisciplinary project. We are really we are trying to get people aware. We are trying to get people to know what personal data is. And trust me, that's not as obvious or as easy as you think it might be. So my point is, we only just started with this concept of personal data. Let's continue with it a little bit more. And at this point, I think it's too early to already review. I'm glad discussing what any potential future concept could be. So that's probably what we will be doing the rest of the session. But I don't think we need to change it within 5, maybe 10 years. Keep in mind, the previous version of the directive remained for 20 years. So that's, I think, the essence of what I wanted to say.
Thank you. Quite conservative views so far. So let me start then with the individual questions. And the first question is to Mr. Peter Hustinx, who is one of the founding fathers of the European data protection law, if I may say so. So I was wondering if you could elaborate on, since you were standing at the foundations of the European data protection law, I was wondering if you could just say a few words about the rationale for picking the concept of personal data, the way it is defined now in the GDPR, as a foundation, as a trigger of data protection. And was it meant to be so broad, or was it meant to be so flexible, to grow so broad in the future?
Well, there are some important steps to follow here. First, there is a clear connection with the genesis, the origin of data protection as a concept, as a separate concept, separate from privacy and the right to respect for privacy. As the scope of privacy was unclear and uncertain, and was basically a negative, defensive concept, the decision was to come up with something wide and broad to provide flexible protection in context. And the concept of personal information or personal data pushed itself to the discussion quite immediately. If you go to the early documents of the Council of Europe, you'll see those notions of personal information and personal data being used interchangeably. In the Convention 108, 1981, long time ago, then for the first time, the definition was as you see on the screen, relating to identified, identifiable, etc. And it has remained the same ever since. But the discussion first then was, what is actually identifiable? Originally, it was very loose-handed. It was easily identifiable. And quickly after, one discovered that it should be reasonably identifiable in context, depending on the circumstances. See the explanatory memo. Then, the directive. A lot of attention, a lot of emphasis is on identifiability, both in the definition and in the preamble, 26. In relation to whom? Absolute or not absolute? No, the answer is reasonably in context for the controller and anyone else, but not theoretic, no. Circumstances, objective circumstances, reasonably. But the 29 group discovered quickly that the way this was interpreted and used in all the member states was very national. They were all following their own little quaint approaches. Some pragmatic, some very, shall I say, fundamentalistic, if you want. And diversity is, of course, not workable as the world is growing larger. So in 29, we've engaged in an exercise to be very robust analysis, and we came up with these 4 boxes. By far the most interesting boxes were the ones on the relating to bit and the identifiability. And there, it's good to emphasize that the definition is not relatable, but it is relating to. So not any relationship, whatever it may be, can matter, but it is the one which is most relevant for protection, to put it very short. That is, it's about you or it has a relevant impact on you. And it pushes this point by not only extending the scope, and it was highlighting, but the 29 group also emphasized the consequences if it does not have a relevant relationship, then it's not within the scope, it's not relevant. And you can encourage that by technical and organizational means. So it was implicitly suggesting limits to the concept. The same as to identifiability. Maybe the most innovative point there was that identifying is not passport information, it's not civil status, it's not the usual thing which we consider as identification in a public law sense. It was, is this unique? Is this distinguishable? Are we focusing on someone? Now, those elements have all made it to the new framework, which will be fully applicable, fully enforceable as of May. No single element has been left out. Quite a few have been in denial for long and are only now discovering this to their detriment. I think that explains some of the sounds we are seeing. But also as to identifiability, the 29 group emphasized this means that not everything is relatable, relating to, and identifiable all of the time. But be aware when this is relevant for your project, because you carry the responsibility. So the idea that this is a concept designed to protect leads to wide scope, and for good reasons it has a wide scope. And if you go through the text, there are examples of things which are not identifiable, not personal data relevant, and others, and there are means to narrowing the scope, which has been tried in all kinds of ways. The discussion about pseudonymization is a case in point. Would this lead to narrowing the scope? No, the answer is it is a very useful practice to protect, but within the scope of the whole protection scheme. What if I know little about a person and it's still within the scope? Well, maybe not always. You need to know more. And this entire discussion is now reflected in the GDPR. If we were to narrow the concept deliberately, then I would say this would not be workable. It would not be allowed under the current human rights framework, the Charter of Fundamental Rights, which has now constitutionalized this concept. You'll find it at the level of the treaty, the charter, the directive, regulation, and a lot of other instruments, all of which OECD, Council of Europe, EU, deal with the same subject. Is today's discussion irrelevant? By far not. But I think we should not focus on revising this concept, but dealing with the consequences of what we have as time goes forward. And there my emphasis would be on responsibility rather than on the threshold question of when does my activity enter the scope? If we were to focus on the threshold conditions, we'll get threshold discussions. If we focus on effectiveness, we get protection. That's, in brief, my approach.
Thank you. So, thank you, Mr. Hustinx, for highlighting that, highlighting the history of the concept and the rationale for adopting such a broad concept. Can you hear me well? I'm not. So, at this point, I think it would be good to go to Maurits, who is the only non-lawyer on this panel and who is a data scientist. And in particular, I want to connect these two speakers. Mr. Hustinx explained that indeed identifiability is not the only element of the notion of personal data, and we know that there is a lot of discussion on the growing capabilities to identify and nearing perfect identification. But there is another element of this notion that is as important as identifiability. In fact, we don't move towards identifiability discussion before we figure out whether or not information relates to a natural person. And this element, relates to, has recently been explained in the Court of Justice decision in Novak. And so in Novak, the court basically followed the test for relating to that the Article 29 Working Party adopted earlier and interpreted this relate to in a very broad manner, saying that relate to means not only relationship in terms of content when information is about a person, but also the relationship in terms of the purpose when data is processed with the purpose to assess or impact a person or his behavior, or also in terms of result when the data is not processed about a person or with the person to assess or impact a person, but the use of the data is likely to impact a person. And this is what I want to ask my question about. You as a data scientist is aware of the current state of art in data analytics, especially artificial intelligence and automated self-learning algorithms. So given the state of art of technology, how realistic is it to say that some data is not likely to relate to people? Let's say, how broad is the scope of the notion of personal data when it comes to relate to and impact on people that the data has?
Yeah, so I would say in the context of this discussion, there are two important points here. One is that a lot of these technologies, the algorithms that could be used to either identify people or relate data that you have to people in some meaningful way are very rapidly evolving and shifting. And hence, and this is, I guess, one of the cores of our discussion, maybe some of the ideas that we're writing down here now, especially when you start thinking about things that are reasonably doable or easily doable, are going to change quite rapidly, and things that didn't seem very reasonable right now or at the time data was collected will be reasonable in a very short period of time, or actually kind of in the blink of an eye. So this is something I think we should be careful about, that lots of data that doesn't seem to relate to people right now might in the future. It also highlights for me, sorry, this is just a kind of a personal anecdote of some of the data that I was working on, and I would love to hear some of you guys' opinion on how this would kind of work out in this framework. It's actually a very simple data set where we're trying to use some machine learning, machine vision, to classify potatoes. You would say this doesn't relate to people necessarily. This is something that people do by hand, sorting potatoes in size. And we put a few cameras on those and see if we could do that automatically. Interestingly, the benchmark that we had there was the performance of a small number of human sorters. We were able to outperform that benchmark by the machine vision, led to firing some of these people and actually automating the process. Is that data that we used, would that trigger this law in the sense that that was data regarding the performance of individual people on their sorting process? Or would that relate much more, which I totally agree with the first speaker, not necessarily as, oh, where is this boundary condition, but is the effectiveness, if I understood this correctly, and hence the negative effect on these people, is that what should have kind of triggered a discussion here? It's maybe just an open question. But,
it goes a little bit against our self-imposed protocol, but are the lawyers on the panel willing to comment on the data on potato sorting and whether or not it's personal data as you think, according to the definition of personal data as we see on the screen?
I'd be happy to comment because this is a very great example which also shows what kind of analysis you need to do before you do these things. If this is about potatoes, just, then I'd say no. Of course, simple. So limit it to the potatoes. But once you say it's also about the people selecting the potatoes, then to that extent, you need to be aware of the fact that this will then deliver personal data. That example is not on potatoes, but on cars in the 29 group. It's an example with those who shows that you can limit impact by being proactive. And so this concept, therefore, encourages smart analysis and raises the question, what are you up to? And if it doesn't have any relevance, let's not argue about the size of the top of a pin, huh? But you say, if this is in fact also about performance measurement, well, then to that extent it's relevant, sure. If it's about economizing the process, as a result of which eventually maybe less people will be required, that's a different thing. I'm not going to argue that it's then relating those individuals. That would be too far-fetched. But if it's performance measurement, absolutely.
Yeah, absolutely. I can only say at Telenet, because I was there longer than I was at Nielsen, I only started two months ago, but at Telenet, I used to say that everything we had about customers, we had about 80% of the customers in Flanders, around more than 2 million customers. So every kind of data we had in my mind was personal data, or should be considered as personal data. I literally said it 1,000 times. Everything we have is personal data. Whether you send an email, watch TV, be able to distract the location from a person or whatever, everything. Yeah. So absolutely, I think it is broad, and I agree that it in itself that is not a problem. To the contrary.
Can I add something? So I agree with the earlier speakers that as long as your research was evaluating individual workers, then it would probably come within the scope of data protection rules. But let's assume for now that that wasn't what you did. It was just generally you showed that your machine did better, so people could be fired. I think that's a great example of something that's clearly outside of the scope of data protection. Also, it's a good example of that should remind us, like, things are not solved in an information society because we have one piece of legislation, even although it's a piece of legislation with more than 90 provisions. This is just a good example of the discussions and problems are not over yet.
I have the qualification to my question, and I address the question to all the panelists. I heard here, well, the data about potatoes, it's really about potatoes, and only when we mean to use it to assess performance of the workers does it potentially become personal data. But if we look at the definition, and I apologize for keeping for sticking with the potatoes, but if we look at the definition of personal data, the data relates to people, not only when, let's say, we intentionally process it for the purpose of assessing or impacting, but also when its use is likely to impact. And so this element for me lacks this notion of intentionality. So obviously, when a company collects data for the purpose of assessing people or adjusting pricing, etc., it is perhaps easily qualifiable as personal. But this element of likely to be used or likely to impact is something that I have interest in specifically. And also because, for instance, when Article 29 Working Party explains the meaning of this notion, they qualify that this impact, the likely impact, does not have to be major, which I interpreted as also can be minor. And where do we draw the boundary between the impact that is major and minor? So the second point is that when talking about the sorting potatoes, basically this is the example of an isolated data processing, one instance of data processing, whereas we are moving to the society, which is basically one big smart city. If we believe this, the profits of the trends in technology development, we will be all living soon in the Internet of Things and even Internet of Bodies, where data is a default overlay of our interaction with the world. And so in these circumstances, is it fair to say that all data, or that we cannot exclude that any data will likely impact people, especially if you consider smart cities as environments that sort of subject individuals to data-driven, environmental design, not only decision-making by public authorities, but whether or not your automated stairs are running faster or slower, or not running at all because you should exercise a little more. So what do you think, Maurits? Let me start with you.
Oh, I don't know if I'm the right one to comment on this. Okay, so I'm kind of stuck with this idea, also what you're saying, hey, at some point maybe everything is personal data, which is also what's happening in the case that you're describing. Now on the other foot, I kind of, why would that be a problem? So are we looking for some definition that separates some parts of data from other parts of data, or is it just really the case that all of these things concern people up to some level, and hence we should be considerate of these things? And so is making sure that some parts are not personal data, is that an aim by itself?
No. But basically, I don't see a problem in the fact that we at some point can recognize all data as personal data. But the problem is in the weight of consequences. Indeed, let's say if the same intensity of data protection obligations applies regardless of the kind of personal data, let's say in some situations perhaps, but it's not about the broad scope of personal data as a notion, but about the consequences of the obligations that are triggered. And I would like to, at this point, move on to David. No longer potatoes, perhaps advertising, consumer targeting. But in your professional experience of working in practice and applying the notion of personal data, how easy is it for industry to apply this definition? So suppose we have, of course, the practical world in which we deal with the, risks as they come, compliance risks and such. And we have the ideal world in which all data protection obligations have to be absolutely enforced when any data, any personal data is processed. So how difficult or easy is it in your practice to distinguish?
It relates more or less to the comment I made earlier and to what, so it's not only my personal experience with Telnet and which is similar to what is my experience now at Nielsen. I talk, of course, with other DPOs and privacy professionals, and they, even the story about the youngest one joining the legal team, I hear it quite often. So, but so the answer to your question, I think, is, again, in a way, we are not there yet. We start as the regulation requires us to do, or we apply as the regulation requires us to a risk-based approach. So we start at the top, I would say. That's definitely what we did at Telnet. It's also what we are doing in Nielsen. We take the most obvious cases or the most risky processing or the probably least supported purposes to start with. So we start with the high risks and we go down, but we haven't, I think we're not yet there where we say, okay, this is really not important. We're not going to do anything. It's probably, we never really thought, is this personal data, or this is maybe personal, but it's so irrelevant, we're not going to do anything or protect it or whatever. So we haven't reached, again, that point where we say, this is too trivial to be working on. We are still at the top with the top risks. We're trying to develop a program. We try to close the biggest gaps. We try to remediate the biggest security concerns. We try to, limit storage duration to an appropriate term. That's also not always obvious. So again, my point is we still haven't reached the point where we say, okay, guys, don't care about this one. If that is a correct answer to your question. I would say we're still in the red and dark orange zone, and we still are not treating the potentially light and green, light orange and green zone.
Well, thank you. I might misread your answer, but so do I understand correctly that basically you deal with the situations that are clearly personal data and then basically structure your compliance as a priority and then structure your compliance indeed from the top, as you say. So I would like to direct my next question then to Maryant, who is representing a data protection NGO, and I wonder what do you think it does to the level of data protection in a company when the compliance is focused on the most clear cases and some the higher priorities and leaving the rest for later?
Right. So we see like an outcry of certain companies saying that it's very difficult to apply certain obligations under GDPR. As we have discussed before today, some of the obligations that we currently have under GDPR already exist since a few years ago. So it's not something new. Just according to EU rules, regardless of the type of personal data you're dealing with, they all deserve the same level of protection. So that means that making a risk assessment might not be the best. I understand the practicalities of it, but obviously what we need is not only good rules. What we need is enforceability of the rules. We also need independent authorities to actually control the implementation of the rules, and that's even part of the article in the charter, and that's why even only the definition of personal data is just a minor thing of a bigger picture. So the fact that a company could be struggling with the fact that maybe all of the data they're handling could be personal data is not a problem per se, as we discussed before. It's more about the bigger picture and the fact that it needs to be taken seriously, because that's why we have the protection and that's why it's a fundamental right.
In this discussion, we have small questions and big questions. The question of the details of the concept of personal data are small, sophisticated questions with big consequences, of course. But as to a big question, there is no doubt that when this was devised 50 years ago, the reality was different from what we have now. So now there is a much more complicated reality impacted by this concept and all the consequences. So that's clear. And then asking how easy is it or how difficult is this to use this concept? Well, companies, governments have a hard time in coping with the consequences. If you read the Breyer case, it's obvious that the German government was taking a conservative position, was just assuming that IP addresses, dynamic IP addresses, as described in that case, did not enter the scope. The 29 group has been explaining this for 20 years. The answer is yes. In the NOAA case, where the question was basically, does a candidate have access to his own exam papers? In EDPS practice, we've taken that position from more or less at the beginning. Yes, because it's about my performance. So some of those consequences are now coming out. And as I've said before, these discoveries do not mean that it's endless, but we need to come to terms with what we have avoided to take seriously for a long time. I'm with Nadezhda, extremely interested in knowing what this will do 5 years, 10 years, 15 years from now. And then I see some changes, but not to the concept of personal data.
Thank you. I think this is the time to close the discussion on the notion of personal data and move to, we will get back to that, don't worry, and move to considering alternatives to a legal regime centered around the notion of personal data. So my next question is to Frederik. So some of your recent research was focusing on the e-privacy reform and the current regime of e-privacy. So I was wondering if you think there are some lessons we could, if we go for a non-personal data-centered regime, because effectively if all data is personal data, well then all basically data protection rules apply to all data. So if we move towards a non-personal data-centered regime of legal protection, can e-privacy directive teach us something in terms of approaches?
So the e-privacy directive and probably the e-privacy regulation, if that will be adopted, gives rules for basically confidentiality of communications. For instance, if I call Nadezhda over our cell phones, the e-privacy rule says to the phone company, you cannot listen in. So these types of rules. And there are rules in there for traffic data, also called metadata, and certain types of location data. Actually, the lesson should probably be, and that is, I've worked on the e-privacy rules for at least 10 years, and it still gives me a headache. It is so incredibly complicated because the e-privacy rules combine data triggers. So the rules for location data are triggered by the concept of location data. Rules for traffic data are triggered by the concept of traffic data, for instance. So that resembles a personal data type trigger, but then they're combined with a different scoping approach, namely, currently basically only telecom companies are subject to the rules, to most of the rules, and these are defined as providers of publicly available electronic communications networks or services, and networks and services are defined differently again. So it's, and this is not a figure of speech, it actually still gives me a headache. So the lessons to draw from the e-privacy discussions is probably do not try to combine several scoping approaches in one regime. Basically, all scholars and lawyers and attorneys I know find the e-privacy rules much, much more complicated than the general data protection rules. And I hope and can imagine that for in 30 years that many of the personal data, like the general data protection framework, let's say the successor or the grandchild of the GDPR will include most of the important e-privacy rules, but that is for the future. For now, it's probably best to finish the revision of the e-privacy regulation, some pragmatism, but yeah, in a couple of decades they should probably be combined.
I chose the example of e-privacy specifically because it is an example of a privacy protection mechanism that does not use the notion of personal data as an anchor. Yeah. Sort of, it aims to protect confidentiality of communications, and this is sort of a certain value that a legal regime wants to protect without using the notion of personal data. So, what do you think about, for instance, if all personal data is if all data eventually becomes personal data, we need to scale we need to have the legal rules applicable to data scalable, if you see what I mean. So if we use these contexts of electronic communications, for instance, or healthcare, or what have you, as a possible threshold, as possible organizing principle to scale the obligations applicable to data processing. What do you think about such an option, basically a next step? If some legal protection should apply to all situations when data is processed, we need to find a next threshold for perhaps different kind or stricter obligations. Could you elaborate on that a little?
Okay, so I think I agree that we should give much thought on the coming situation, which has some problematic aspects, that basically we will be leaking and sending and leaving data trails every second of the day. Some people also at night if they have a smartwatch, etc. And it's very well possible that at some point, it's completely expected, of course, that the GDPR has to be revised at some point, and I could imagine that we have larger carve-outs for certain types of household use, basically like personal use. You don't, etc. So of course there will be many tweaks and revisions needed. But I do not think the scoping should be done by being conservative again, by narrowing the personal data concept again, and seeing how extremely complicated the e-privacy rules are. I don't think you should limit the scope by saying only certain types of companies are subject to the rules. There is indeed an interesting underlying rationale in the e-privacy rules, which is the fundamental right, the human right to secrecy of communications or confidentiality of communications. But as a human right, it's pretty vague and sounds beautiful as well. But the way it's implemented in the e-privacy rules is still, well, then it's triggered by the phrase communication, which is defined in a rather complicated way, actually. So although the human rights at that level, it sounds more abstract, in practice, the e-privacy rules actually resemble more complicated version of normal data protection law.
Thank you. Yeah.
I think I share the view of Frederik that what is really strange is that e-privacy seems to be protecting a type of data, location, content of communication, which is perfectly fine, but only if a certain actor is processing it. It's not to say a provider of an electronic communications network and service. So in practice, I understand it as if I'm using some kind of Telnet service or Gmail and they obtain my location, that will be in the scope. But if I use Google Maps, which is not a communications tool, but a navigation tool, that will be out of the scope, which is strange to explain. There's two apps of the same firm, one might be in and one might be out the scope. That's the way I understand it. So what the missed opportunity here is that we didn't, so absolutely have to get rid of the limiting criterion of the type of actor processing a certain type of data, because there is a good reason to have something like an e-privacy regulation, and again, that is the content of what I'm exchanging with you or you on my phone. I like to have it protected. And also, I think location. So content and location are two potentially sensitive types of data that we as users, because I'm thinking as a user now, would like to have protected. And there's a good argument to me. But we didn't reflect. We said, okay, we had an ISDN directive, 97/66, if I remember correctly, which protected the confidentiality of ISDN, because interactive digital telephony, lots of privacy issues, and we had an ISDN directive. We reviewed it in 2002 because we had the scope of e-communications, and we reviewed it again today, and we just continue the current situation, and that's how we ended up with location is protected if a telecoms provider is processing it. But it's actually, you can't explain. Location can be just as important if my, I don't know, health insurance is processing it, or my company car insurance company or whatever. So absolutely, I agree with Frederik that the combination of types of data and a specific actor is not a good thing. I think that's absolutely true.
Thank you. Yeah. We have 3 minutes to wrap up and then allow some time for a discussion.
Okay.
So I would like
let's
to
use my time well.
Okay.
I think it's not true that the e-privacy directive is not based on personal data concept. It's a specification of the general using various means, including confidentiality, etc. But location data, etc., is an example of personal data. Now, the big question. I could very well imagine that 10, 20 years from now, a post-GDPR system would use different architecture. And then if all the rights and obligations we now see and we struggle to enforce have landed well in practice, I think we could relax some of the tools to get these things done. One thing is interesting, that is the GDPR is also based on the so-called progressive risk-based approach, meaning if the risks are bigger, you need to do more, if the risks are less, you need to do less. It doesn't say don't do anything, but it says less. Now, I can imagine that as the burden of proof is now on the controller, that there will be some provision saying, if you demonstrate in a convincing way that there are no risks at all, then don't do anything in that respect. So then you get, by reallocating the burden of proof, something which is very close to fiddling with the definition of personal data itself. But then, my little anecdote. There is a famous Dutch case of a bank which was selling investment products, risky investment products. And many of its clients really lost a lot of money. They sued the bank, and they wanted to have access to all the data relating to them as a client at the point where the project was sold to them. The bank's position was, this is only limited data. This is the data as agreed, the top part of the box. You put your signature underneath. The clients were arguing this was all the data which was used by the bank to make the sale a profitable position for them. The Supreme Court decided the latter. And that's a perfect example of things which have a relevant impact on you. It tells the story that not everything which is only about sort of an intermediary making a big profit on a sale is necessarily not related to the client as well. Rethink this. And so even in a system where you have minor impact, there is still the right to have access to the data if there is a relevant impact. And making distinctions. You're a good sell, you're a bad sell, you are a good prospect, is immensely important for the data economy which we have ahead of us. So better keep this well and we shift the emphasis to the architecture. So that maybe you do not have to have all those risk assessment and all those DPAs involved in all those different things. They will be selecting as we go forward, but it triggers the system in the right direction.
At this point, I would like to close the panel and open the floor for discussion. So I think I'll move. We don't have a microphone for the audience, so as I was explaining the procedure. If you speak up, can you hear me? Or is it off? If you speak up, I will repeat your question, so the question is also heard for the recording. Yes, so, yes, please. If you agree to the recording. Oh, you should have received the stickers for that, okay. Yes.
I agree. Well, I'm glad we came up with an example of something that isn't personal data, because I thought starting this panel we'd be ending and still not finding something which is not personal data. And I agree the framework or the concept is sufficiently broad and the obligations for the most part sufficiently scalable. But I'm very optimistic with regarding to the relating to criterion, looking that triggers impact. I'm not so certain that the identified or identifiable will still tend to stand the test between this and 20 years' time. I'm thinking about a recent statement made by the Irish Data Protection Commissioner saying that facial detection, which just detects the face but does not take a picture of it in order to trigger an ad or a different type of interaction, does not constitute processing of personal data. And so I'm happy to hear other views on whether or not that's the correct interpretation, but I think that when it comes to when you look at content, purpose, or impact, treating somebody different, relating to, you're covered, right? But if you're saying this person's standing in front of a billboard, the only way to visually identify that person might be through the camera from the shop owner across the street or by going to the telco provider, et cetera, thinking about means likely to be used to identify. And so I'm wondering, as we move to smart cities, the scenario that you raised, whether there are going to be certain types of sensors interplaying with each other, which might have that impact, but taken by themselves at the level of individual controllers might not necessarily be that identified or identifiable. Well aware that combinations of attributes lead to indirect identifiability. But
So, if I understand correctly, this question perhaps is rightly posed to Maurits, who is a data scientist, perhaps more knowledgeable, or anybody. So, if I understand your question correctly,
not facial recognition, but facial detection. There's a lot of industry out there saying, oh, this is not processing personal data, digital advertising boards, interactive advertising, because what we collect, you know, it's just the sound of footsteps, or what we collect, it's not really a picture of a face, it's just kind of a detection that a face is there, but we don't have any way of, you know, linking that to an identifiable individual, but we might show an ad differently based on gender, based on height, based on, you know, these types of elements. And so for me, it's kind of like the beginning of a scenario where there might be different impact, so you would satisfy the relating to criterion, but you're going to struggle to find an objective argument to say this is reasonably identifiable in all instances. I'm saying in all instances.
any answers from the panel?
Facial detection and facial recognition is, I think, an example of something which is per se identifiable. Maybe, I mean, I need to know more about the facts of a case like that. And I can imagine scenarios where it's doubtful, but my starting position would be that if you use this as the trigger to distinguish, is it going to be green or red, commercial or whatever, then that, now, are these pictures retained? No. So, you know, so it is a scenario at the verge of what makes sense. So the question is, what is the impact? What is the sort of the scope for possible protection? Well, it's discriminatory, yes, depending on the consequences. But if you frame it in a way that it is minor, superficial, maybe we just forget about this. But I would never say in public that facial recognition is not identifiable. No, same. My starting position is this makes me very curious.
I propose the following. We'll take 3 questions now in a row, and then I'll ask all the panelists to give answers to those 3 questions, or the interesting bits.
Charles Rabb, University of Edinburgh. This could be a question, it's also an observation on, I think, what Frederik was saying, and also Nadezhda, about maybe in 10, 20, 30 years' time, we would need to think about different scopes, different kinds of behavior and so on. And I think that if that is to become a kind of threshold in which we identify different kinds of data, it's not a very stable one, because already the categories of social and economic life as we have known them are changing. What constitutes a domain? Health, transport, communications, education, and so forth are all becoming very, very fuzzy and very blurred, particularly when you think about the Internet of Things, merging those kinds of things. Health and social care, for example. Health and social care and self-development through wearable, monitoring and so on. Now, that's going to accelerate probably in the future. And it also, in fact, makes it difficult to apply the idea of contextual integrity, because the norms that pertain in those different contexts will be changing and in various ways, so that we can no longer identify what is a context with sufficient stability to apply norms, including data protection norms.
So 2 more questions, remarks, and then comments of the panelists. If there are none, then I'll give the floor to the panelists.
last remark was to me by Professor Raap. He says, oh yeah, everybody heard it. That's actually a super good point. Perhaps it was a bad idea of me. Indeed, sector-specific rules, like the e-privacy rules we have in Europe, are complicated. In the US, you have a HIPAA with pretty good personal data protection-like rules for hospitals. Yeah. For hospitals, which don't apply to data brokers who deal with the same, who sell the similar medical data. So granted, so this is a very strong argument you give in favor of basically continuing the current system by overarching data protection rules for basically the whole society. Still, I'm not completely convinced. One counter-argument is we still expect other things in a hospital than we expect elsewhere. So, but probably your argument is stronger.
Historically, sector-specific versus omnibus was one of those classic, the questions. What is happening now increasingly in Europe that we have overarching general rules, but do not underestimate the number of sector-specific or relation-specific or situation-specific rules on top of that. Just a recent addition, new rules for financial service institutions. And there will be all kinds of rules which are actually specifications of the GDPR in their own right. The reality of the day is that we will have international, national, professional, interrelational, contractual, all kinds of rules interacting with each other. That is the reality. I have seen in my mandate at EDPS dozens of examples of sector or relation-related data protection rules, specifications. Don't underestimate these. Already now, and that will certainly not change. Now, some of those rules need to be revisited frequently because as society becomes more dynamic, those relations change color. Uber, is this taxi or is it internet? Well, according to taxi-specific rules, it's a taxi firm. Not everybody will agree, but that's the answer for the moment. And that's just an example of surprises. My big question is, how are we going to deal with the universe of situations when the universe is increasing? You cannot argue in reality that everything is important, so I have sympathy for the priorities. We start with what is really urgent, but need to be aware that if your agenda is that you come to something late, that one of your clients can ask for it now, and then you need to deal with it now. But not everything. So I would take issue with Nadezhda when she says everything will be personal data. Well, not everything, and certainly not everything all the time. So we need to be concentrating on which is in relevant circumstances. Intelligent cities, well, you see a lot of data relevant, personal relevant, privacy relevant situations. Yes, so we need to build architectures which limit the bad sides and sort of enhances the good parts of that. It can be done. This is called privacy enhancing technology. We have panels on this. And it's being encouraged either within the scope of the rules or outside of the scope of the rules, but they need to be done. So don't waste our time. Do it.
So I propose the last rapid remarks from the two speakers.
Understood.
Okay.
Oh, same. I think this was a nice.
Yeah, absolutely.
Thank you very much to all the